I want to discuss today the suit that is our right to arms, the ingredients being the Constitution of the Union and that of Tennessee, and the Supreme Court rulings, both state and federal, which provide guidance for their use by government, which, by the way, is supposed to work for the people, not rule them. In Bruin, the Supreme Court plainly illustrated the recipe for determining which firearms regulations are constitutional. Text and history are the stock that begins that. Bruin tells us, and I quote, "If the plaintiff's proposed course of conduct falls within the Second Amendment's plain text, then that conduct is presumptively protected." And here I see us all as plaintiffs, as our current governments, both state and federal, continually attempt to deny our ability to enjoy our God-given rights. No matter how many justifications the state may bring forth for denying the right to keep and bear arms, the Second Amendment, by its enshrinement in the Constitution per Heller, necessarily takes certain policy choices off the table. Per Bruin, the government must demonstrate that the regulation is consistent with this nation's historical tradition of firearms regulations. Only then can a law be enforced constitutionally. Some spice that is required. The people means all Americans. To bear simply means to carry. And most relevant here, arms includes all instruments that include bearable arms. All this from the Heller decision. Now, just as we would cut out the rotten parts of potatoes as we prepare a meal, we need to take out violent criminals from the ability to enjoy the right to arms legally. But of course, that does not keep that subset from procuring firearms, criminals not obeying any laws. Should we then punish the innocent for the crimes of the guilty? A very recent ingredient that builds on this process is the Kwame Raoul v. J. Robert Pritzker case regarding the assault weapons ban in Illinois. The record evidence establishes a positive fact. There can be no reasonable dispute that the firearms and magazines banned by Illinois are among the most popular firearms and magazines in the country, and their owners use them in overwhelming numbers for self-defense. Added to that prescription was the venerable Scalia and Heller dollop, affirmed in Bruin. Arms, as a prima facie matter, extends to modern firearms, even those which were not in existence at the time of the founding. Federal Judge Stephen P. McGlynn said in that case, "The state's response is largely a policy position paper, devoid of relevance to the framework established by Heller and Bruin to assess the constitutionality of state laws." Our own Supreme Court ruled in 1870, in the Andrews v. State case, the right to keep arms necessarily involves the right to purchase them, to keep them in a state of efficiency for use, and to purchase and provide ammunition suitable for such arms, and to keep them in repair. And clearly for this purpose, a man would have the right to carry them to and from his home, and no one could claim that the legislature had the right to punish him for it without violating this clause of the Constitution, Article 1, Section 26. We the people are the chefs. We are the shoppers who decide on the items and pay for them that governments may use to pass laws. Choose wisely. In Heller, Scalia quoted St. George Tucker, "This may be considered as the true palladium of liberty. The right to self-defense is the first law of nature. In most governments, it has been the study of rulers to confine the right within the narrowest limits possible. Whenever standing armies are kept up, and the right of the people to keep and bear arms is, under any color or pretext whatsoever, prohibited, liberty, if not already annihilated, is on the brink of destruction. Do not let your employees tell you what to put on your plate."